My name is Abhishek and I'm a legal intern at LEXIS and Company, and today's my topic is PRASHANT BHUSHAN case. So the Supreme Court found that the two tweets by lawyer PRASHANT BHUSHAN amounts to serious contempt of court. So let us talk about the tweets which are the main highlight of this case. One tweet has about the role of the last four Chief Justice of India, and the other one was about the current CJI riding an expensive motorcycle while the court was in lockdown. So the court responded to the first tweet. As such, the court held that the tweet tends to give an impression that the Supreme Court has in the last 6 years played a role in the destruction of the Indian democracy. It said that the tweet tends to shake the public confidence in the institution of judiciary. It also said that the tweet undermines the dignity and authority of the institution of the Supreme Court and the Chief Justice of India and directly affronts the majesty of law. So the court responded to the second tweet. As such, the bench held that this tweet was not against the CJI in his individual capacity but as the head of the judiciary. It took the exception to the lockdown remark and said that from March 23 to August 4, its various benches had 879 sittings. It noted that Bhushan himself not only appeared as a lawyer during this period but also challenged the FIR against him. The court refused to accept his tweet as a written out of anguish. It said the magnanimity cannot be stretched to such an extent that may amount to weakness in dealing with an attack on the very foundation of the institution of judiciary. So what is so worrying about this Supreme Court response? The court rejected the argument that the tweet was only a matter of opinion, although experts like former Supreme Court judges have said or written similar things. In 2018, the senior most Supreme Court judge had held a press conference to say that the credibility of the highest judiciary is at stake. They asserted that democracy would not survive as an independent judiciary is the hallmark of successful democracy. The Supreme Court had tolerated such a strong indictment of itself and then CJI Justice Deepak Mishra. Now it has chosen not to ignore tweets by lawyer activities. So what is the criminal contempt in this? The criminal contempt under section 2 clause C of the Contempt of Court Act 1971 means publication which scandalize or tend to scandalize or lower or tend to lower the authority of any court, or prejudice or interferes or to tends to interfere with the due course of any judicial proceeding, or interferes or tend to interfere with or obstruct or tend to obstruct the administration of justice in any other manner. So what were the court's key arguments? So actual interference. It rejected the argument that the tweet has not really interfered with the administration of justice. It relied on Brahma Prakash Sharma 1953 verdict. This verdict had held that it is enough if a statement is likely or tend in any way to interfere with the proper administration of justice. The bench also relied on C.K. Devthari 1971 verdict. In this, the Supreme Court held that an attack on a judge is respect of a judgment or past conduct has adverse effect on the due administration of justice. It also said that this sort of attack has an inevitable effect of undermining the confidence of public in the judiciary. Scandalizing of court, the Supreme Court bench cited Kanta Mishra 1974 verdict. In this verdict, the Supreme Court had held that scandalizing of the court is a species of contempt, and a common form is a vilification of the judge. The question the court has to ask is whether the vilification is of the judge as a judge or as an individual. If the latter, the judge is left to his private remedies and the court has no power to commit for contempt. The bench held that the fair criticism of judges, if made in good faith in public interest, is not contempt. But how to ascertain the good faith is the million-dollar question. So, how good faith could be ascertained? The bench said that for ascertaining good faith and the public interest, the courts have to see all the surrounding circumstances. These circumstances should include the person responsible for comments, his knowledge in the field and the intended purpose. So, is it different from previous ruling on contempt? So there is nothing new in the judgment compared to earlier ones on the contempt of law, several of which the bench quoted. In case involving Bhushan himself, 2001, the Supreme Court had held that personal criticism of a judge does not amount to fair criticism. In 2006, the government brought in an amendment which provides truth as defense provided it is bona fide and public interest. The expression scandalizing the court has not been defined. In 1988, the Supreme Court held that a criticism of the court that doesn't hamper the administration of justice cannot be punished as contempt. This raises the question whether a mere tweet can really obstruct the administration of justice. And it also raises the question whether a judicial dignity is so fragile that it would get lowered in mature Indian people's eyes because of a lawyer's opinion. So, why is the contempt law seen as a problematic? The judge himself acts as a prosecutor and victim and starts with the presumption of guilt rather than innocence. So, contempt proceedings are quasi-criminal and summary in nature. So, that's it. Thank you.